This video is made for educational purposes only and cannot be taken as legal advice. You will find a link to the full judgment in the description. Kuddus v Chief Constable of Leicestershire Constabulary, House of Lords, the 7th of June 2001. There is no rule of law preventing the award of exemplary damages against police officers. The fact that no case of misfeasance in public office had led to such awards before 1964 did not prevent such an award now. Although damages are generally not to be punitive, they might be so in appropriate cases. The distinction in Rooks v Barnard between misbehavior by government officers and officers of independent companies should no longer be followed. The test was whether the basic criteria set down in Rooks v Barnard were met. Lord Nichols said, "Exemplary damages or punitive damages, the terms are synonymous, stand apart from awards of compensatory damages. They are additional to an award which is intended to compensate a plaintiff fully for the loss he has suffered, both pecuniary and non-pecuniary. They are intended to punish and deter, and the availability of exemplary damages has played a significant role in buttressing civil liberties, in claims for false imprisonment and wrongful arrest. From time to time cases do arise where awards of compensatory damages are perceived as inadequate. The nature of the defendant's conduct calls for a further response from the courts. On occasion, conscious wrongdoing by a defendant is so outrageous, his disregard for the plaintiff's rights so contumelious, that something more is needed to show that the law will not tolerate such behavior. Without an award of exemplary damages, justice will not have been done. Exemplary damages, as a remedy of last resort, fill what would otherwise be a regrettable lacuna. Exemplary damages could in principle be awarded where misfeasance in public office was established. Lord Hutton discussed Rooks v Barnard, saying, "In a case in which exemplary damages are appropriate, a jury should be directed that if, but only if, the sum which they have in mind to award as compensation, which may, of course, be a sum aggravated by the way in which the defendant has behaved to the plaintiff, is inadequate to punish him for his outrageous conduct. To mark their disapproval of such conduct and to deter him from repeating it, then it can award some larger sum. The conduct had to be outrageous and to be such that it called for exemplary damages to mark disapproval, to deter and to vindicate the strength of the law." Lord Nichols, Lord Hutton.